Advocate Johnson, you remember your and my engagement of yesterday about factual conclusions that are lacking in factual substratum supporting the factual conclusions.
Yes, Chair.
I will suggest this to you. I see the content of paragraph 2 to yet again make factual conclusions, which to my mind are not different in substance to the factual conclusions we dealt with yesterday.
I understand.
And do you agree?
I agree.
So I do not see the basis on which you would, based on this affidavit, have come to the conclusion that now there is enough for an investigation to be conducted. If you accept that these are factual conclusions that are not supported by factual allegations that support the conclusions. So I do not see how you get to the answer you gave to Ms. Silolo.
Chair, that was just my reading and understanding of it. And I indicated I see this for the first time today.
Yes.
However,
But,
I follow the sequence of the reasoning that is made by the Chair.
Do you agree with the suggestion I'm making?
I agree with your suggestion.
Thank you.
Thank you, Chair.
Can I just
Yes.
draw to Advocate Johnson's attention? Advocate Johnson, appointments to senior management at SAPS level are governed by National Instruction 11 of 2017. And it appears to me that IDAC is not even familiar with this national instruction, because when Colonel Padayaki was here, he struggled to give answers in relation to this document. Yet this is the document that governs every step in the appointment of individuals such as the Brigadier we're talking about here. And clause 17 of this document, I hope it has been provided to you, the national instruction. I see the attorneys seem to have stepped out, but it's National Instruction 11 of 2017. I had asked that a copy be made for you. Maybe, yeah. Lisa? The second last page, clause 15. Just look at the first page first.
The one that starts with the purpose.
No, look at the cover page. It says National Instruction 11 of 2017, appointments to posts in senior management service.
I see that.
And then if you go to clause 15, which is the second last page,
I am there, Commissioner.
yeah, it says if a candidate is appointed and it appears that the candidate did not comply with the requirements of the appointment, that's paragraph A, we can skip B because B relates to the non-disclosure of criminal record and goes to C. If it appears that the candidate provided false information in his or her application or letter of acceptance, or D, the candidate is unable to take up the post. Look at what follows. The matter must be reported, and I emphasize the must be reported to the Divisional Commissioner Personnel Management for a recommendation to the National Commissioner on whether or not the candidate may retain his or her appointment. Do you see that?
I see that.
So the prescripts at SAPS govern a situation where an allegation like this is made, that Because IDAC is not qualified to determine whether somebody qualifies or does not qualify. If such an issue has arisen, it then gets reported. In fact, it must be reported to that person so that that person can investigate and then make a recommendation to the National Commissioner, because it is the National Commissioner of Police that appoints people to this post. Do you see that?
I see that.
But it bothers me that your investigator, because I don't think this would have been brought to your attention, but your investigators did not even pay attention to a national instruction which governs appointments at this level. And later on, when we go through the provisions of this document, you will see that it governs how panels are set up, who recommends, who approves. It governs how candidates are interviewed and scored. It governs how the recommendation to appoint is then made, and who recommends and who appoints. But your investigators say nothing about this. In fact, they pay no regard to it, because even the definition of what is appropriate management experience, not management position, don't confuse the two. Appropriate management experience, the only place where you find that definition is in this document.
Okay.
And your investigators, for reasons that are not clear to me, paid no attention to this and proceeded instead to target a civilian and deal with her in a manner that I have serious difficulties with. So going back to the affidavit, because it goes together, so let's go back to the affidavit. It goes together with the cover page, because the cover page on 682 is described as the statement. And the reason why you have an affidavit is because everything Mr. Adams wants to say cannot fit in this page, on this page 682. So the affidavit has to be an annexure to this page, which says South African Police Service Statement, and then has description of the offense, where the offense took place, what the offense is. So if you just look at the particulars of the offense, it says the date of the offense is October 2024. Do you see that?
I see that.
So there's a specific date. And then it says the scene of the offense. It says it is at Crime Intelligence Offices, Priska Street, Erasmus Kloof, Pretoria. Do you see that?
I see that.
So that's what Mr. Adams limits himself to, because this document gave him options. You will see when it talks about date and time of the incident, he could have chosen the starting point and the end point, but he limited himself to a particular date. And then same with the scene of the offense. It gives him the option between, did it start in Cape Town and continue and conclude in Pretoria? But he limits himself to a particular date when a particular decision was made, and he says, that is the offense, that is the date of the offense, it took place at Crime Intelligence Offices. Do you see that?
I see that, sir.
But IDAC's investigation goes to April, it goes to May, it goes to June, and it targets this individual civilian in circumstances that are simply not justified by the referral or the statement or the affidavit itself.
I see that.
Do you want to comment? Because we'll come back to that later.
I see that, and I see that once you read the national instruction of the police. I see the point that you make.
Yeah. Even on panels, it's very clear. If there's a problem with a panel, there's a procedure for that. If there's a problem with a shortlisting, there's a procedure for that. And this document governs all those things.
I take the point. I see the point.
Thank you, Commissioner Kumalo. For the record, that national instruction for future readers is at file 3, page 706. Exhibit File 3, page 706. Now, staying with the statement then, the second statement of January 2025. Do you still have your second statement, the A1 by Mr. Adams? You recall I said it's page 682?
Yes.
Yes. Now I'm still at paragraph 2.
Of yes, 683.
683, thanks.
Thank you.
Yesterday day before yesterday, I've lost track of time now, I apologize. But you highlighted the provisions of section 29 of the NPA Act and 29 capital A, which states an investigator may, subject to control and direction of an ID, exercise such powers and perform such duties. I'm interested in that phrase, subject to the control and direction. And my proposal to you is at this juncture that you do quality control or quality check to determine whether to proceed with this investigation. And in order to do so, you must satisfy yourself that whatever is described in the referral affidavit and firstly complies with section 27 of the Act, but most importantly, brings you or brings that complaint within the confines of section 7. Remember section 7?
Correct. That
we dealt with. Now that we are here, what about all these documents leads you to a conclusion that this matter relates to serious, high-profile, or complex corruption, commercial or financial crimes? As Commissioner Khumalo points out, whatever is clarified by the second statement is that this is about employing a civilian. And there is a process in terms of a national instruction to address that issue. So it cannot be, I suggest, that employment could come anywhere close to section 7, capital A. How do you get there? We are looking at the same information, you and I now. And I conclude that you could not reasonably have come to the conclusion that we are now within 7A. I want to understand how you get there.
So, Counsel, I get there in terms of the allegation of fraud and corruption and the unduly benefiting of a civilian. Hence, I said initially, I'm not going back on agreeing with the sufficiency hereof. At the time, the assessment is whether there is fraud and corruption and whether someone unduly benefited, and that it does allow for further investigation.
So you're suggesting that you went by section 7, bracket 1, capital A, B. You say that what the referral points out gets nowhere close to the provisions of sub A. So this is just sheer forgery. No, you said fraud and corruption.
That is correct.
So you skipped A, the requirement that the matter must be serious, high profile, or complex corruption, commercial or financial crime cases. You completely ignored that part.
Not ignored that part, that it falls within the ambit of the 7B.
But then what is so serious, high profile, involving complex corruption, commercial or financial, in what we have just looked at?
It is in the main the fraud and the undue benefit.
What's complex about those?
No, not that it is complex. I if you'd allow me to.
Oh, no, my question was, I took it that IDAC's mandate is in the main captured in sub A. So firstly, you remember we had a conversation about the determination of whether when a matter is brought to you, you must, a determination of whether it's serious. Now, we may differ about how it should be read, but one would expect that high profile or complex corruption, commercial or financial, they must feature somewhere in there. Now, I want to know, now that we are here on the 6th of January, what is so serious, high profile or complex corruption, what is commercial, or what exposes a serious commercial or financial crime? Because I would suggest, absent that, then IDAC ought to walk away. What's your response?
So if I could just first indicate where I saw that it fell, and I have a response to.
No, you'll come to where you saw it fell. You have to, at least for my benefit, get us past A, which is your starting point.
Yes. So for me, counsel, that even if you don't have A, there is B, which relates to the fraud, forgery, uttering, theft, any offense involving dishonesty. That is my reading of where it fell.
So you read this section to provide the Office of the Investigating Directorate shall carry out any functions incidental to investigations, and we have A,
yes,
the serious high profile, or relating to fraud, just like SAPS.
Yes.
No difference between you and SAPS?
No.
No difference between you and Hawks?
No.
What are the various mandates of these institutions, if you also overlap? And I read B as suggesting relating to additional related offenses. So it's additional to something, and I suggest it's additional to A. IDAC's entry point has got to be A. In the absence of that, I don't see how IDAC gets to investigate.
If you look at
maybe Ms. Johnson, as you answer the question about your mandate, you should also have in mind and speak to why IDAC was formed in the first place. We always had the SAPS, which had always had the mandate to investigate fraud, forgery, uttering, and all of that. So maybe consider also why was IDAC formed in the first place as you answer what is your mandate and how you interpret this 71A.
Okay, Commissioner. So under capital 1A, we have relating to serious, high-profile or complex corruption, and then it has commercial or financial crimes. And that then takes you to the additional, which is in B, which is fraud. There is nothing about the serious, high-profile or complex corruption is precisely what we were formulated for, Chair, is to deal with serious, high-profile, complex corruption matters in the main, the related offenses, but to deal with those that arise from the commissions of inquiry, the state captured, the party, and the Nugent, and then other matters that may be referred to IDAC, be they Section 28(1)A or by Section 27. But the main gist of the question by Commissioner Baloy is IDAC was formulated to deal with serious, complex, high-profile corruption matters.
And you say a theft that SAPS can investigate is a matter that IDAC was formed to investigate. And I'm going to give you a truly ridiculous example. A theft of a motor vehicle. If Mr. Adams had referred to that in a Section 27 and said a vehicle was stolen, are you saying that you would be entitled to investigate it under B?
No.
Why? Why not?
Because that that matter falls within a different mandate, and that matter falls within the mandate of SAPS. If you'd allow me to just, and then I know
you can expand.
I know you'd have other questions, Commissioner Baloy. The theft relates to a very specific environment. It relates to the crime intelligence environment, and it relates to the theft of the secret funds or the slush funds, as he put it.
No, but that's not what he's saying in that paragraph 2. Remember, he gave you this affidavit, section 27, which contains no facts whatsoever. We've agreed that. It contains no factual material. That's why you went to him, or Perumal, somebody went back to him to get further clarification or further detail, now the grounds to support the suspicion. And all he comes out with is that paragraph 2, which is about unduly benefiting a civilian who did not qualify when there were 3 other people. What does it have to do with your mandate?
Commissioner Baloy, from what I understood, and the investigators will have to give the detail, I understood as follows, that when they got those dockets, the 4 dockets, they took additional statements in each of those dockets. This would have been the one that relates to the allegations of the appointment, but that there would have been other statements that would relate to the theft of the funds, etc., that would take that matter differently. But that is the information I have, as they took additional statements, Chair, per docket. This matter for me relates to a very specific.
So, yeah, even with that, I mean, we can limit it to this specific matter, and the question remains, what is it about this specific matter? You say there are other files or other dockets. That's where we will find that it falls within your mandate, but we are talking about this specific docket, that on this docket where this statement belongs, if all you have in this docket is the section 27, and then you have this statement, it looks like this is a matter that belongs to the SAPS at best. And we have that national instruction that tells the SAPS how to deal with this matter.
If I could just add that from what I understand, that after the investigations continued, the docket doesn't consist only of. Whether or not that is sufficient is a debate. But if you take it just on this and just on the section 27, it goes back to the question that Council asked, as well as yourselves, Commissioner, then it should have fallen within the national instruction of the police.
But remember also that at this point you have already made a decision to investigate, and I don't mean to reopen that debate that we've had, but this in fact is now part of an investigation, because you have already made the decision to investigate. So even if you had sight of this post the decision to investigate, it has no consequence to your decision, because you've already made the decision to investigate. And when you made the decision, you didn't even have this. This, in fact, further clarifies that this grievance, as relates to this employee in particular, and her ending up being charged, is really a grievance about someone having lost out on an appointment, and it's no more than that.
I see the point you make, except that I just go back to the answer I gave, that more investigations were done, Chair, and it is based on the more investigations that were done that would have then translated to the charge. As it stands.
And the charge of gratification against her.
Yes.
Okay.
So, but as it stands here, I took the point and agreed to the point that if this is all that there was, then it does fall under the national instruction and should have been elevated, Chair.
Okay, thank you.
Let me invite you, Advocate, to engage in a close interpretative exercise. As Ms. Silo touched on it, paragraph B of subsection 1, uppercase A, refers to additional related. I want you to please give meaning to additional. Additional to what? And to also give meaning to related. Related to what? Can you please do that?
So just on my reading.
Not just your reading.
On a reading.
Yes.
Yes. The related to additional related offences, Chair, read from paragraph A above, is relating to serious, high-profile, or complex corruption, or commercial or financial crime cases. I take the commercial or financial crime cases relating to fraud, etc.
So at least you accept that IDAC cannot just jump and investigate any fraud, any forgery, any uttering, any theft.
Not from the reading of the Act.
So it must be additional to what's envisaged in paragraph
There must
A.
be a relationship with paragraph A.
Okay. Oh, all right. I just wanted to be sure. Thank you.
Thank you, Chair. Now, on that understanding, we have this section 27. We have the dockets, the A1s in the dockets. As we now have come to learn, that was the only thing that was in the dockets. We have this latest A1 statement from Mr. Adams. Then can you please indicate what those documents collectively, how those documents collectively land you at A? We know their contents now.
Sorry, Counsel, repeat.
Those documents, the original section 27, the A1s in the respective dockets, which is what the legal advisor at SUB said, that's all that was contained in the dockets, and I assume that is precisely what you found. You couldn't have found any more than the inspectorate had. And thirdly, Mr. Adams's January statement, the one we're looking at now with 2 paragraphs. What in any of those documents collectively led you to the conclusion that the documents disclose serious, high-profile, complex corruption, commercial, and financial crimes?
I'm saying, Counsel, that it's not restricted to those 3 because further investigations were done, and it is on a reading of all the investigation in its totality that led to the charges as they were preferred.
They say you have rushed to the charges. Remember that we had said the section 27 was incomplete. You exercised your discretion, and you say you normally do, which is to request further substantiation from a referee. Now you have it, and we agreed in the morning that that is for purposes of you determining whether to even initiate an investigation. And in order to do so, you must first establish jurisdiction, that you have that jurisdiction to entertain this claim. What, as they stand, is that not your point to have asked yourself whether this complaint at least squarely locates you within A? And I say this because it can be that you investigate with the hope that somewhere, you will come across some damning facts that will then justify A. We first have to be in A before you investigate. Otherwise, the process is deeply concerning.
On a reading of those documents, I'm not going to be able to take my point further than indicate that based on the fraud and the undue benefit, and the fact that it is commercial and or financial crimes, we moved from A into the B. And that therefore justified investigations continuing. We're not there at charges. It is based on these documents that you refer to, Counsel.
Advocate Johnson, the section 27 doesn't contain anything that is a basis for you to say, yes, there's a financial crime, possibly, that is being committed that requires further investigation. It doesn't contain that. It doesn't contain, so let me see, it doesn't contain anything where you say any facts. We settled that all that affidavit does is to list suspicions. It doesn't say what is the basis of those suspicions, which we all agreed sub B, 27B, requires that there must be grounds for it. Otherwise, you are going to be fishing, you know, and I don't think that's what your powers are meant for. So we've agreed that affidavit doesn't contain any matter that takes you to a place on its own where you end up saying, yes, that which is contemplated in one capital AA, which is serious, high-profile or complex corruption, commercial or financial crime, it doesn't contain those kind of facts that ground the suspicion. You then go and get an affidavit, or your people go and get an affidavit. All that affidavit does is tell you that a civilian was unduly benefited over employees within crime intelligence. That's all it tells you. But this is later. This is an affidavit in January, so it's actually irrelevant for purposes of your decision, what triggered your decision. Okay. All you had to trigger your decision was the section 27. And on the section 27, you could not have had a reasonable basis that there is the commission of a crime. And your explanation since yesterday and today, and I must say the same with Colonel Pariachi, is it seems your office or IDAC took the view that we have an affidavit, vague as it is, we go fishing, we'll find something. There must be something to find. So you went in either because you had been told, which is not in the section 27 affidavit, you had been told there is something to find, it's just not contained in the affidavit, and you went looking for that. Or you went not knowing at all that you'll find something. Which is a typical fishing exercise. Your mandate and your powers don't contemplate you doing that. That's why there's that trigger provision. But in this case, it seems there was a failure in that trigger. You just did not have enough to trigger that investigation. And the question that eventually must be asked and must be answered is, why would you do that? And it's a question that is qualified to be asked because we are dealing with an organization which has lawyers in it. We have you who has experience in what this act deals with, the powers that it gives you. You have prosecutors, you have a lot of people. It's simply unimaginable that in your office, no one would have said to you, ID, we do not have the triggering requirements. It's simply unimaginable that no lawyer in your office said we don't have jurisdiction to investigate this. And maybe let me ask you the question directly. That you went as far as you did, does it mean no single lawyer in your office said to you, we don't have jurisdiction to investigate on the basis of that section 27, And even after you received this affidavit, no one said, we lack jurisdiction.
No. And just to perhaps then indicate that based on those three documents, Section 2813 of the NPA Act says that if the investigating director considers it necessary to hear evidence in order to enable him or her to determine if there are reasonable grounds to conduct an investigation in terms of subsection 1A, the investigating director may hold a preparatory investigation.
So you say to us you had that preparatory investigation.
That is the preparatory investigation that is conducted so that where there is, it is in order to determine if there are reasonable grounds. And when you look at the proposition that is being put to myself, is when you look at these, there's no reasonable or there's insufficient. I'm saying that Section 2813 allows us to conduct an investigation to determine if, in fact, there are reasonable grounds.
I accept that. My question still, after the preparatory investigation was done, no single lawyer in the office said to you, we do not have the jurisdiction to prefer these charges?
No.
Okay, thank you.
And staying with 2813, for process purposes, my reading of it, and I want to test if it's correct, is that if you, as the investigating director, consider it necessary to hear evidence, you do so to enable you to determine if there are reasonable grounds to conduct an investigation. So you're not at investigation point yet.
No, it's a preparatory.
Yes. So 2813 allows you to hear evidence or obtain evidence to determine whether or not there are grounds for an investigation. The point we're making to you, or at least I'm making to you, is as at the 6th of January, there are not even any grounds at all to conduct a preparatory investigation to determine whether to conduct a full-blown investigation, because the matter doesn't fall within IDAC mandate. So I get confused by your reliance on 2813, because 2813 is not carte blanche for you to conduct a full-blown investigation on flimsy, non-existent grounds.
It is not a full-blown investigation. What it does allow is where we need to still determine if there are reasonable grounds for an investigation. Yes. And I'm saying that given what we had at the time is the Section 27, the 4 dockets, then we needed to conduct a preparatory investigation in order to determine whether or not there are reasonable grounds to continue with an investigation.
No, so apologies, because now I'm thoroughly confused. Remember, we start with 27. We said the original affidavit received, it doesn't assist you at all. You advise the commissioners that you have the power to call for further information to consider the referral in its totality. Now you've got the flimsy A1 statements in the various dockets, and you have this January 6th affidavit. At that point, you now have a total picture. You must make a call on that Section 27. Does it now bring you within Section 7 of the Act? Does it bring it within the jurisdiction of IDAC? And I'm suggesting to you that considered collectively, you can't even get into Section 7A, capital A, sub A. That's the first. So it's only because it's only once you are in that, you then determine whether, because what you are headed for now is to trigger a preliminary to determine whether to investigate. You are not in full investigative mode yet. Correct. You are not intruding into people's lives and their private affairs. It's a preliminary investigation or preparatory investigation that informs whether or not to conduct, because it could potentially end at 2813, and the response coming back is that no, we won't go any further. So that's the second step, correct? Are you with me? Now, when does the 2813 step end? What must you have? Must you have the full picture of all the crimes that you have alluded to in your authorization of Section 2813 before you authorize a further investigation? The levels of investigations have to be different, I would assume.
That is correct.
Okay. Now, what must you obtain in terms of 2813 to help you determine whether to conduct a full-blown investigation?
You must have enough evidence that there are reasonable, that the suspicions are reasonable and that there are reasonable grounds on which to conduct that full-blown investigation. There must be sufficient evidence collected in the 2813 process. It is then, Commissioners, that there is an evaluation thereof and whether or not to move into. So the 2813 Council does allow for quite a few investigative mechanisms, and so whilst it is a preparatory investigation, you are able to issue summonses, conduct search and seizures, etc., in order to move into that kind of investigative phase and therefore to collect evidence to make the determination on whether or not there are reasonable grounds to move into a full investigation.
Advocate Johnson, I just want to understand whether you are of the view that your Section 2713 discretion is unfettered. I do see the words, if you as the ID consider it necessary, you may then institute the preliminary investigation. Is that discretion unfettered in the sense that it depends purely on what you consider necessary, regardless of the circumstances?
I do not believe it's an unfettered. It is
Can
based
you,
on the.
Oh, yes, yes.
Sorry, it is based on the information that is presented, as was the case with the team, in terms of how they assess and briefing me on that. It's not an unfettered.
Continue.
Maybe if
Okay.
Chair makes a follow-up point, maybe I might be able to clear
yes, I want you to, just for a moment, for me to understand as a matter of law what the fetters are. If you say it is not unfettered, I want, as a matter of law, to understand what those fetters are. Can you give them to me without reference to the facts that we have here? Because what you just did in your last answer was to refer to what happened here. So, as a matter of law, what exactly would fetter the exercise of your discretion?
So, there would have to be, as we indicated in the Section 27, are there reasonable grounds to suspect that an offense has been committed, the grounds on which it is based, and additional information. In the main, that is what one considers. And any other additional information could then be whatever else they've brought to the fore. And I say that that is what determines it in terms of the discretion on whether or not to move. Sorry, Chair. Also, if we had asked for additional information in order to augment the Section 27, whatever that may have been. And that guides the discretion whether or not, given what we have, it is not sufficient for a reasonable suspicion, but there is sufficiency. And so we can go ahead and conduct a preparatory investigation in order to arrive at.
So absent that reasonable suspicion, if I understand you correctly, you cannot begin to do a 2713 preliminary investigation. So that's the reasonable suspicion is your entry point to 2713, you say?
To the 2813.
2813, I'm very sorry.
Correct.
All right, thank you.
On that score, at file 8, the documents you provided yesterday, file 8, page 3288.
Sorry. Do I still need to keep the exhibit bundle at hand?
Which one, ma'am?
The one where we were going through Fadil Adams' affidavit, the additional affidavit? Close at hand but not open?
Close at hand, but yes, not open. At 3288, apologies. The document goes as far as 3300, and I see it's dated the 30th day of May 2025. Do you see that?
I've got that.
Okay. Now, if we go back to 3288, this is an application for an investigation in terms of section 28(1).
That is correct.
So that suggests to me that now we are past the 2813 preliminary investigation.
And that investigations were conducted and further evidence would have been obtained between the period 6 December 2024 to the date of this matter.
If I understand the provisions of section 2813 is that you conduct some preliminary investigations to determine whether to have a section 28 investigation.
Correct.
And I take it what we have at 3288, we're at a point where now we are applying for an authorization to investigate in terms of section 28(1).
That is
so the true investigation now starts.
correct.
Am I understanding it correctly? And that application is made on the 30th of May, 2025.
That is correct.
And as we know, on the same date, at page 3304,
Sorry, 33?
3304, same file. Three 3304 is designations in terms of section 28(2)A. So you are designating a team in this matter
That is correct.
for the investigations.
For the investigation and prosecution.
Yes. And this team is established, designated by you on the 8th of August, 2025. If you look at 3306.
The designations on 3302
Yes, ma'am.
are the designations dated the 30th of May, 2025.
Yes.
Yes.
No. 33?
03.
Yes.
Yes.
I'm now at 3304.
This would have been where additional persons would have come onto the team afterwards, but the original designation, Council, is on 3303. So the commissioners, the 28 is signed on the 30th of May.
Yeah. Okay.
And the designation for the persons who are to deal with it are on 3303.
I accept your point, correct? So the first designation is 3302, that's dated the 30th of May 2025. 2025.
That is correct.
The document I looked at, you say, was adding to the designated team in August.
As happens in all matters, if you add persons to an investigation, regardless of who they may be, you must designate them to the investigation.
I'm with you. I accept
and
that.
that
Thank you.
Just for context for why there is a later one.
Thank you for that clarification. Then,
sorry, I think Commissioner Khumalo has a...
Oh, yes, please.
I think it's confusion more than anything. I had understood during your first day of testimony that the designated investigator came to you in February to say, please authorize summons so that we can get these documents in relation to the generals that appear in those summonses, and that was sometime in February. There was also a summons that went to BMW again in February. Now, they could not do that unless they were designated as investigators, because for them to say, I need to go into BMW and get documents and interview BMW people, because that's what the summons said. And that was all in the first or second week of February. That can only mean there must have been an earlier designation appointing them as investigators, because if the designation only happens at the end of May, what were they doing talking to BMW management in February of 2025 and interviewing senior managers at BMW in February 2025? So do you see why I'm lost?
May I explain? Yes. So, Commissioner Khumalo, when the Section 2813 preparatory investigation was authorized on the 6th of December, it also designates persons to the investigation. And because they are designated to that preparatory investigation, they are able to conduct investigations.
May I assist? Please answer that question with reference to page 3282. Same file. You say when the Section 2813 preliminary investigation is authorized, it also designates persons who should conduct the investigations. And that is the document we discussed from yesterday. That is your authorization.
Yes.
And it's followed by 3285.
Yes.
You say that's a designation in terms of 2813. Is that the document you reference?
That is
dated
correct.
the 6th of December 2024.
That is correct.
With those documents, then you may respond to the Commissioner's question.
On page 3286, Commissioner Khumalo, is the list of persons that were designated on the 6th of December, so that there are persons designated to conduct investigations. And as I indicated, Section 2813 does allow you investigative processes, including being able to interview a witness, subpoena documents, and so on.
So there were two designations / authorizations.
Yes, the first being preparatory, and once that is summarized and done, they then bring together the May application.
Advocate Silom covered, thank you.
Thank you.
Have I clarified it, Commissioner?
You have, thank you.
While I hope you have your act close by, and my reading of 2813, why do you suggest it requires a designation? When I read 2813 with 28 sub 2 sub A, I draw a distinction, whereas it's 28 sub 2 sub A, that requires you to designate people to investigate. But that's a full-blown investigation now. 2813 doesn't do so, and if anything, it just simply says you, the investigating director, may hold a preparatory investigation. I accept, for present purposes, that you may delegate that power. But it doesn't require you to establish a whole team of people to investigate. It's preliminary.
I understand what you're saying,
Yes.
Counsel. But out of practice, we do designate persons to the investigation, preparatory or otherwise, or else it'll go back to Commissioner Beloy's point of you have people running around on fishing expeditions and doing as they please. And how do we account for what was done, who did it? Back to Commissioner Kumalo's question of how do you have people interviewing senior persons, etc. It is the designation assists in identifying persons to be able to conduct the activities that that team determines are for investigation. We have always done
Yes.
a designation for both so that there is accountability and there's responsibility for the activities and for the actions.
And I'll tell you perhaps where that designation in terms of 2813 gives me challenges. We have now agreed that you authorized a formal Section 28 investigation on the 30th of May.
That is correct.
That's when the investigation starts.
Incorrect.
Tell me.
So Section 2813 is a preparatory investigation. It allows you to take statements. It allows you to interview persons. It allows you to subpoena documents in terms of Section 28.6, which is what you would see the investigators had done.
Let's deal with that issue with reference to the wording of 2813. 2813 allows you, as the investigating director, it specifically singles you out, advocate, to hear evidence to enable you to determine if there are reasonable grounds to conduct an investigation. So it's a process to enable you to make a decision whether or not to investigate. Correct?
Correct.
Now, we know that on the 6th, you started the preparatory investigation, and by the 30th, you say there is sufficient material to conduct an investigation. So the actual investigation only starts from the 30th of May. Otherwise, you are investigating with, while you are in the 2813 mode. And whatever exercise you are undertaking at 2813 determines whether or not you should investigate in the first place. So you can't have a full-blown investigation in 2813.
It's not a full-blown
Okay.
investigation.
Now, we know that you came to the conclusion that we must investigate on the 30th of May as per the authorization. I don't know if this speaks to the efficiencies of IDAC. By the 26th of June, 2025, less than a month later, after you authorized the actual investigation, that list of people was arrested and appearing before court. So your investigation actually took exactly 3 weeks, not more. What did that investigation unearth that was already not in your files by the 30th of May?
The investigations out of that preparatory investigation would have commenced after the 6th of December 2024.
Yes.
And I do hear what you say, Counsel, but in terms of the preparatory investigation, I read it with Section 7.3 of the Act that says an investigating director shall be assisted in the exercise of his or her powers and the performance of his or her functions or duties, and lists those people. So it is not the investigating director herself who conducts the preparatory investigation. And the persons designated thereto conduct the investigation on behalf of the investigating director. We go back to what is allowed in terms of Section 28 as an investigative tool. They are allowed to interview witnesses. They are allowed to obtain subpoena and obtain documents, etc. And that is what had happened. So by the time we get to, If I can just take a moment,
Yes.
I'm just feeling slightly lightheaded.
Take a moment.
Yeah. Thank you, Chair. So by the time we get to the 30th of May, there would have been investigations done. What the test is, on the 30th of May, in the presentation of the Section 28 application, is a summation of everything obtained to date. Does it now make or create that reasonable suspicion we say was not there in the initial phase? And if it therefore fulfills that requirement, we can then authorize the full-blown investigation.
Okay.
It doesn't mean, may I continue? It doesn't mean that whatever investigation was done in the 2813 process falls away and something new starts with the 28-1. Sorry, Commissioner.
Sorry, finish. You can finish.
No,
Sorry,
no,
I thought
it's
you
okay.
finished. Okay. Can I just clear my confusion? And maybe I should have done these sentences earlier. At page 3283 of the same file, you authorize a section 2813 on the 6th of December, 2024. And then at page 3300, you authorize a section 28(1)A, preparatory investigation. You say to conduct a preparatory investigation in terms of 28(1)A, and this is on the 30th of May, 2025. Is it, because in both letters, you speak, on the one you speak of a preparatory investigation in May 2025. You see where I'm reading? At 3300?
That word preparatory is not, I have decided to conduct an investigation in terms of section 28(1)A. It's not preparatory anymore, Commissioner.
My copy reads to conduct a preparatory.
No, I'm not disputing your copy. I'm saying it should not read preparatory because it is a section 28(1)A.
It is now a full-blown.
It is a full-blown investigation.
Okay, thank you.
Okay, I accept that. Now, I want to know what investigations were conducted between the 30th of May and the 26th of June when they were arrested. Because only then, as of the 30th of May, full-blown investigations are authorized.
I would have to find out in the break and come back to you about
Okay,
what all
please
was
do.
done, because I can't list what was done after the 30th of May.
And that date is
I know
key.
it needs an answer.
That date is key because there is a reason why the statute distinguishes between preparatory investigations and actual investigations and provides that you may not do investigations unless duly authorized. You grant the authorization. And Section 28 sub 13 allows you to conduct preparatory investigations to enable you to determine whether or not you should authorize. Why I say it's important, it appears to me, and perhaps I'm looking at it wrong, that IDAC used the mechanics of Section 2813 to conduct a full-blown investigation, which would render it wholly unauthorized. And then to post facto grant the authorization on the 30th of May, which opened the way for applying for arrest warrants and actually arresting them. So no investigation was conducted after the 30th of May. It was all before the 30th of May. And that has got to be because there are benefits to hiding under the cover of a preliminary investigation, conduct a full-blown investigation, cure that defect by a late authorization, and in less than 4 weeks, be ready to arrest. It's quite curious that you end there. Because if that's how it happens, I'll applaud the efficiencies within IDAC.
I will come back with
Thank you.
the response, commissioners, if that is fine.
Chair, while we await the responses, might this then be an opportune time to take the lunch adjournment? Because I want to finish this point. Thank you.
Yes, we will resume at 2 p.m. Let's
you, Chair.
adjourn.